channel. So today with me here is Lincoln Majoko. Did I say that right?
Yes.
Okay. Welcome, Lincoln. How are you? How's business? How's the legal field?
Thank you very much, Zoda. I'm well, thank you. I'm glad to be here, and thank you very much for extending this invitation for me to be here to discuss important issues of the law.
All right. So just a basic introduction. Lincoln is a legal practitioner under the employ of Mishinkomo Legal Practice, and today he will be helping us and basically guiding us on certain aspects of the law in real estate. So we'll start with some questions that we have here that I drafted here, basically discussing the clauses in the agreement of sale. We will start probably with explaining the risk and profit clause.
Thank you very much, Zoda. So maybe before I get into that, I just want to make it abundantly clear that in Zimbabwe you're allowed to enter into an oral agreement of sale, but the risks are there, which is that where there is a dispute, it's your word against the other person's word, which is why we need to have written contracts, because where there is a dispute, you can then refer to that document as an embodiment of what the parties agreed. So it's very important that people understand the type of contract and the nature of the contract that they are signing or that they are entering into, because there is various laws that regulate those contracts. For example, if you want to buy state land, you need to obtain what is called a certificate of no present interest. Because the state land, the government through the minister has to notify you that they have no interest whatsoever in that particular piece of land at that time. So this discusses the risk aspect from a legal perspective. Because if you enter into a contract without complying with those provisions, that means your contract is invalid or null and void, which means that you're at risk of losing out your investment. So you think, my contract is good, my contract is done, but there is a law that says you're supposed to do A, B, C, D before you enter into that contract. So failure to follow the peremptory provisions of those laws would then mean that that contract is invalid. So that is the risk side from the legal perspective. But there is also the risk side in terms of agreements which are valid and lawful. So we have complied with the law, we have signed our agreement, and then the question is, at what stage does risk pass from the buyer to the seller?
From the seller to the buyer.
To the seller to the buyer. Yes, from the seller to the buyer. In some instances where you are selling the property voustus, that is to say where there are defects, some defects you can see them, some you can't. We are simply saying that you are buying the property as is. So you are buying that property without risk of those defects. So under normal circumstances, there is a clause in terms of which risk passes at the conclusion of the agreement. So the immediate question is, what does the conclusion of the agreement mean or entail? In most cases, we have clauses where both parties have to sign the agreement. So after the seller and the buyer have signed the agreements, we're saying the contract is concluded. And at that stage, risk may pass. But with some agreements, they will say, well, even after you've concluded that agreement, risk will only pass when the buyer takes occupation of that piece of property. Which means when you take physical occupation. So when you're taking your property from your house to the seller's house, then we are saying risk is passed to the buyer as at that stage. So those are generally the instances where risk passes from the seller to the buyer.
When you were talking, you mentioned of something that most clients ask about, the voustus clause. I don't know if you can elaborate a bit more on that. Like, what exactly does it imply when you find a contract of sale having that clause, and usually what terms does it comprise of?
Thank you very much, and that's a very pertinent question, because in most cases, because of one reason or the other, a person might decide to buy a second-hand product. That is to say, a house that has been used. So that house is coming with certain defects. Maybe the roof is leaking, or maybe there are some cracks in the walls. So in other words, it's not perfect 100%. So when you are saying voustus, you are simply saying you are buying the property as is. So you actually have to inspect the property. If you notice that there are roofs, the roof is leaking, and you proceed to buy that property, you are saying that you're okay with buying the property in the state that it is in.
All right.
So Vustos clause simply protects the seller from any future claims against the buyer, who then says, but you sold me this property with a leaking roof.
Yes.
The law is simply saying, as the buyer, you have a duty to inspect that property. If you have inspected and you've signed that agreement, it means that you are saying you are agreeing with the state of that building. However, there is an exception to that law.
Okay.
Yes.
Interesting.
There is an exception to that law in instances where there is fraudulent misrepresentation. So a seller might know that there is a defect, which defect cannot be noticed by any reasonable person. So they hide that defect from the buyer, or they take steps to prevent the buyer from knowing or from discovering that there is a defect. Under those circumstances, the law permits the buyer to sue the seller for the loss that they have incurred for that defect. So under those circumstances where we have fraudulent misrepresentation, the law is simply saying we are not going to condone fraud, we are not going to promote fraud, and because of this policy, we're not going to encourage this. So you are allowed where the seller has misrepresented to you, and there's no way you could have noticed that there was a defect in that property, to then sue the seller under those circumstances.
That's a very
quite interesting
point. And it might be a very difficult one to argue, but anyway.
So just inspect the property.
It's necessary to inspect the property, as you're hearing from the legal practitioner here. And we move on to the next clause that people talk about on encumbrances that the title of the property might have. How best can we talk about this, and how best can we guide our clients on how to deal and how to best understand this certain clause?
Thank you very much. That's another pertinent question, because of our economy, we are always going to banks or financial institutions to get some loans using our property. So you might be buying a property which is encumbered, as you correctly said, maybe by a loan from a financial institution. And so if you buy that property with that loan, you are taking that property as is, which means that you are taking also the loan. So you are assuming the liability to then repay a loan which was taken by maybe the former owner of that house. Which is why legal practitioners, as well as real estate agents, become important in this aspect of the law or the transaction. Because they are the persons that can actually go to the deeds registries and check whether that property has any encumbrances or not. So there you need to have expert people, you need to have trusted people, professionals to do that for you. Well, you can do it for yourself, but it would be faster. It would also be better to allow professionals to do that for you. So we always go to the deeds to have a deed search. We check whether that property is encumbered or not. We advise our client, look, the house that you want to buy, yes, is good, but there is an encumbrance, there is a loan, and these are the rights of the bank or the financial institution, etc. The risk which is there is obvious. Like I've said, you are assuming a loan on behalf of someone, and you have to repay it. So you really need to just consult the professionals and make sure that everything is spot on and everything is in order.
All right. Still on the clauses of the agreement of sale, there's a certain important clause that everyone is interested in when they enter into a contract of sale. When they enter in, they want to know and they want to be protected in the case of breach. Right. So we've had some clients saying, I don't feel like this is really protecting me, etc. So I don't know, probably you can explain on that specific clause and
Thank you very much. Breach is one important aspect of an agreement, because if somebody doesn't want to comply with their obligations, then either you have to go to court to force them, or you have to use other means. But they have to be lawful means. I emphasize. They have to be lawful means.
That's an important point.
For a person to repay back your or to comply with certain obligations of the law. So Maybe just a subheading before that.
All right.
There are contracts where there's a condition precedent to that contract. So let's say you enter into your agreement, you want to buy a house, but the seller says, well, you are going to take occupation of the house until you have paid the full amount of the purchase price.
All right.
Which is to say that until you comply with your obligations, the contract is not perfect in a way. It is there, but it is not perfect.
Okay.
It has to be perfected by a person doing something.
All right.
In other instances, I'm sure you've seen betting contracts where somebody says, if you predict correctly the scoreline, I'm going to give you this much amount. So if you don't predict correctly, it means that person has no obligation to pay you that amount.
Yeah.
So there are contracts like that where there is a condition precedent. Somebody says, well, I'm going to pass it on to you if this happens, which means if that thing doesn't happen, then there is no contract per se. That is not breach. That is simply a contract which is not perfect.
Okay, with a condition.
With a condition.
All right.
That's a conditional contract,
Okay.
right? Then let's go to breach, where the contract is perfect. And then somebody, you have complied with the obligation, you have paid your money, somebody has to pass title to you, and now they start giving reasons. So the first thing that you can do is to sue for what is called specific performance. Right? You're essentially going to court and asking for an order that directs the seller to transfer title to yourself.
All right.
Yes.
Okay.
And that can be done through the courts. You can go to any court that you like. You get that order. Once you get that order, in most instances, we have an order that then says if the seller fails to do that, the sheriff of the court is then permitted to do all the necessary steps to ensure that transfer is title is transferred to you.
Okay.
So that's one. Two, there are other people that would then say, friend, fine, let's cancel it. Just give me back my purchase price.
Okay.
The money that I paid to you.
All
It's
right.
fine, you can keep your property, just give me back my money. But that may be risky. I'm sure you've heard about the recent judgment on the 1:1 policy.
Yeah.
Where in
Yeah.
2019 the government woke up and said if you had debts and liabilities in USD, they are
you
now
know.
1:1 with the Zimbabwean dollar.
Yeah.
So you might be one of the unlucky ones. You paid your purchase price in USD, and now government is saying, oh, it's 1:1 with the Zimbabwean dollar. And that person is coming back with bond notes and saying, I'm going to pay you back, and it's 1:1 gauge.
Yeah.
So that may be risky. In other circumstances, I think those are the main remedies which are available to a particular party who has had a breach. But there is also a damages part or a damages clause, which then comes into play.
Yeah.
Damages, we are saying, on top of the purchase price that you are claiming back, you can also sue for damages. For example, you may have incurred emotional shock. Take for instance, you had promised your girlfriend that you're going to transfer that property to them, and this person is refusing to transfer this property to you, and now you feel embarrassed before your girlfriend. So you can sue for that. You can sue for emotional trauma and say, you traumatized me because of your conduct, and so I'm suing for damages. So you are permitted to do that as well.
Okay.
In short, those are the main remedies that are available
on the breach clause.
On the breach clause.
All right. Okay, that has been a lot. Thank you so much, Lincoln. That was a lot explained, and thank you so much for listening. And if you wish to have any other detailed information shared concerning specifically the contract of sale in the legal practice, don't hesitate to comment in the comment section. Don't forget to comment, like, and subscribe. Thank you.
Thank you.